Code of Professional Responsibility. Canon 22. Canon 22. A lawyer shall withdraw his services only for good cause and upon notice appropriate in the circumstances. A client has the absolute right to discharge his attorney at any time with or without cause or even against his consent. The existence or non-existence of a just cause is important only in determining the right of an attorney to compensation for services rendered. With just cause, lawyer is not necessarily deprived of his right to be paid for his services. He may only be deprived of such right if the cause for his dismissal constitutes itself a sufficient legal obstacle to recovery. Without just cause, and no express written agreement as to fees reasonable value of his services up to date of his dismissal, and there is written agreement and the fee stipulated is absolute and reasonable, full payment of compensation, and fee stipulated is contingent. If dismissed before the conclusion of the action, reasonable value of his services, quantum meriat. If contingency occurs or client prevents its occurrence, full amount. Note, the lawyer should question his discharge. Otherwise, he will be allowed to recover on quantum meriat basis. Quantum meriat means a reasonable sum of money to be paid for services rendered or work done when the amount due is not stipulated in a legally enforceable. Here are some instances where the client performs its right to change a lawyer. First, the client's loss of confidence in his lawyer deprives the relation of that special element of trust which furnishes the basis of the client's right to dismiss him. A client is also free to change his counsel in a pending case and thereafter retain another lawyer to represent him. That manner of changing a lawyer does not need the consent of the lawyer to be dismissed, nor does it require approval of the court. The relation of attorney and client may be terminated by the client, by the lawyer or by the court, or by reason of circumstances beyond the control of the client or the lawyer. The termination of the attorney-client relationship entails certain duties on the part of the client and his lawyer. However, lawyers can only withdraw from a case under Canon 22. An attorney may only retire from a case either by written consent of his client or by permission of the court after due notice and hearing, in which event the attorney should see to it that the name of the new lawyer is recorded in the case. A lawyer who desires to retire from an action without the written consent of his client must file a petition for withdrawal in court and must wait for the court's approval. This will be discussed further under Canon 22.01. Limitations on client's right. The attorney may, in the discretion of the court, intervene in the case to protect his right to fees. A client may not be permitted to abuse his right to discharge his counsel, as an excuse to secure repeated extensions of time to file a pleading or to indefinitely avoid a trial. Necessity of notice of discharge. No formal notice of discharge by the client to his lawyer is necessary. Any act of the client indicating an unmistakable purpose to terminate the relation is sufficient. But insofar as the court and the adverse party are concerned, the severance of the relation of attorney and client is not effective until a notice of discharge by the client or a manifestation clearly indicating that purpose is filed with the court and a copy thereof served upon the adverse party. Before that formality is complied with, any judicial notice sent to counsel is binding upon the client. The duty of the lawyer, upon being informed by his client that his services have been dispensed with, is to file a notice of withdrawal with the client's conformity. Effect of discharge of attorney. He cannot pretend to continue representing his client. However, if he reappears as counsel, it is presumed that he has been reemployed by the client. Death or incapacity of client. As the relation of attorney and client is personal and one of agency, it terminates upon the death of the client. Thereafter, the attorney loses his standing in court to represent the deceased client or the latter's estate, unless he is retained by the administrator, executor, or legal representative of the deceased client. The relation of attorney and client also terminates upon the incapacity or incompetency of a client during the pendency of the litigation, the reason being that the client loses the legal capacity to contract or to control the subject matter of the action. It shall be the duty of the attorney to inform the court promptly of the death, incapacity or incompetency of his client and to give the name and residence of his executor, administrator, guardian, or other legal representative. Case, Lim v. Villarosa, AC number 5303. Please note that only facts, issues, and ruling relating to Canon 22 shall be discussed on this case. Facts. Umberto C. Lim Jr., attorney-in-fact of Lumot A. Jalandoni, filed a verified complaint for disbarment against respondent attorney Nicanor V. Villarosa on July 7, 2000. Attorney Villarosa was the counsel of Lumot Jalandoni, et al. On a civil case. While the civil case was pending for litigation, attorney Villarosa withdrew from the case without the consent of Jalandoni, et al. The untimely and unauthorized withdrawal of attorney Villarosa caused irreparable damage. An injury to Jalandoni, et al. A highly meritorious case in favor of his client suddenly suffered unexpected defeat. Issue: whether or not attorney Villarosa violated Canon 22. Ruling: yes. The court held that attorney Villarosa violated the Canon 22 of the Code of Professional Responsibility. An attorney may only retire from a case either by written consent of his client or by permission of the court after due notice and hearing, in which event the attorney should see to it that the name of the new lawyer is recorded in the case. A lawyer who desires to retire from an action without the written consent of his client must file a petition for withdrawal in court. Attorney Villarosa must serve a copy of his petition upon his client and the adverse party at least 3 days before the date set for hearing, otherwise the court may treat the application as a mere scrap of paper. Attorney Villarosa made no such move and he admitted that he withdrew as counsel on April 26, 1999, which withdrawal was supposedly approved by the court on April 28, 1999. The conformity of Jalandoni was only presumed by attorney Villarosa, because of the appearance of another counsel in court, supposedly in his place. A client may discharge his attorney at any time with or without cause and thereafter employ another lawyer who may then enter his appearance. Thus, it has been held that a client is free to change his counsel in a pending case and thereafter retain another lawyer to represent him. That manner of changing a lawyer does not need the consent of the lawyer to be dismissed, nor does it require approval of the court.